Hello. Let's say somebody passed away, unfortunately, and you are one of the presumed heirs, like one of the children or brothers and sisters, parents, or for whatever reason you believe that you should be an heir according to the will left by the deceased person, but you are not sure because there were things that were discussed, maybe by that person, maybe in front of witnesses, but still, like, where is the document? Or how do I know if there is a document? And in such a situation, a will search becomes not just a formality, it becomes a cornerstone of every further process, every step you think to take after. Or, for example, you live somewhere like far away. We're talking of Quebec all the time, of course, and somebody just died in Quebec. And somebody in Quebec, maybe one of your siblings, maybe one of your relatives, maybe second, third, fourth wife or husband of that person, tells you that there is a will, that you get nothing, and that everything goes to that person, or any other information, but you cannot verify it because that person says, well, you are not one of the heirs, so I will not give you a will. So if there is a way to obtain it on your own, yes, at least in a situation when you're a presumed heir, meaning that you would have been an heir if there was no will, according to the Civil Code and Code of Civil Procedure of Quebec. And this is what we're talking about today. We're talking about a will search. This might be a problem in many jurisdictions because most of the jurisdictions that I'm aware of, they don't have some centralized register of wills, and it might be in the hands of some lawyer, some notary, in some courthouse, and there are many resources online which provide you an opportunity to have a search. But still, if you don't find anything, that does not necessarily mean that there is no will. It only means that the will is not registered there. Still, at least in Quebec, that's where you start the process. According to the Civil Code of Quebec, there are three possible valid wills. It can be a will prepared and signed specifically before a notary in Quebec, or Quebec notary. Not any other notary or notary public, just for the sake of Quebec validity. It should be prepared by Quebec notary. Such a will is authentic without probate, so it's valid just on the moment when somebody who signed the will died, if that's the last will, of course. So to validate that will, there should be a will search, just to prove that that is the last will, there is no other. There might be two other kinds of wills which are not made before a notary. Might be before two witnesses, and if you prepare a will with a lawyer, probably it will fall within that category. So the lawyer and somebody else will be the witnesses. And by the way, remember, if you prepare such a will, thinking sometimes with a valid reason that it's less expensive than a Quebec notary's will, then to proceed further, you'll need an affidavit from at least one witness that he or she actually was there, saw the testator signing, signed after, and saw how the other witness signed. Without that, it will be a difficulty later on. And a will can be handwritten, meaning that written by the testator's own hand from top to bottom. with all the details, mentioning name, date, with the signature, with initial pages, preferably, and so forth, so that, well, that would be completely attributed to that person. Again, according to at least Quebec rules, to become a will, something does not necessarily have to dispose of the property or of all of the property. It might be simply a revocation of all the previous will. So I do hereby revoke all my previous wills. Therefore, no will is valid from that moment. It might be a will only appointing the liquidator, executor, trustee, administrator, depending on the jurisdiction. Like the titles are different, the gist is the same. In Quebec, we call it the liquidator. And again, the liquidator then would proceed with the distribution of whatever is there according to the rules of legal devolution, if nothing is in the will. The will might only dispose of some particular piece of property, saying that this I want to go to that person, meaning that everything else again would be disposed according to the rules of legal devolution, and so forth. Anyway, so any document containing at least some of those provisions clearly, so it's not that it could be construed that way, but it's clear from the text. Even if it's just handwritten something on a postcard, but it says, like, I want this gold chain to go to my niece, name, signature, and that's it. It might be seen as a will, or at least as a codicil, meaning that a valid addition to an existing will. But again, as you understand, if there are usually almost no questions about a will prepared by a notary, because the notary should know, wills prepared on a personal initiative before two witnesses or handwritten, they might contain difficulties in interpretation and understanding even. Therefore, those two kinds of will are subject to probate. If nobody is contesting, if everything is clear, usually it's done before a notary in Quebec again. But if there is a contestation, it's done before a court. In that case, if somebody brings up such a will, even if it's not registered, as we discussed before, then to proceed with the probate, such a person will have to prove to a notary, to the court, that the interested persons, those who would have been heirs otherwise, or who are mentioned in the will as heirs, that those persons be notified, the proof of that. So if this is the process, then you expect that you'd be notified. If you are not, then it's a procedural error. There might be consequences regarding the validity of the will, regarding the distribution. There might be personal responsibility of those, and so forth and so forth. But even if you think that someone was really dishonest and proceeded with probate without mentioning you, so you were not notified, then again, it's usually a judicial process, and therefore this information can be found if you specifically search for that on your own or with a lawyer's help in a courthouse or courthouses where you think the process might be applied for and might go on. Usually it's the jurisdiction where the deceased died or where the liquidator lives and where the estate account and the whole process is located. Sometimes it's a different place. Might be also where some immovable property is located, so there should be some search, but still the information should be somewhere there, because without such a probate, the will is not valid. The banks will not accept it, for example, or the notary to transfer property from the name of the deceased to somebody else will not accept such a kind of a will without a probate. So there will be some trace somewhere about that. But let's say we are talking about a notarial or sometimes a will made and deposited with a lawyer in Quebec. Those wills usually can be discovered by a will search process. So, as you understand, there should be like 2 will search steps before a chamber of notaries, or Chambre de notaire de Quebec, and Barreau de Quebec, or Quebec Bar, or Law Society of Quebec. So, to proceed, usually you'll need birth certificates from one and another. You can apply for both online. And as I mentioned, if you think that the will was not registered, then you could look for the records if there was any probate. And that way, you could finally find if there was a will. And then, when you do the will search and obtain those certificates, there should be a name of a lawyer or notary who is in possession of the will itself, and then you could get to that person and present evidence that without a will you would have been one of the heirs, and therefore you have a right to see the will. If you don't have this straightforward way, because you're not one of the presumed heirs, then still, if you have at least some indication that you probably are mentioned in the will, then you could go to court asking a court authorization to deliver to you a copy of such a will so that you could verify. But there you will again need some evidence. To proceed with the will search, you'll need a copy of a death certificate, which is itself discoverable and can be ordered online from the Directeur d'État Civil, or like Registrar of Civil Status in Quebec. If you have a proof of death from a funeral home, that also will help. To apply, you'll need a copy of the death certificate, the deceased social insurance number, or medical insurance number, or both, usually to identify, because there might be several persons with the same name, or some persons being immigrants, they can have their names spelled differently in different documents, so you'll have to mention. Basically, those numbers are used to identify a particular person for whom you're asking. If you don't have that information, probably you'll need the help of a notary or a lawyer, because, well, we have our own ways to proceed with this search, a little bit more simplified, but still. The idea, one way or another, is to obtain a death certificate and a will search based on the death certificate for a correct person, like that particular person. So you apply, you pay some fee, not very high, you wait, and you get that, and you get the information where you can find a will, if there is a registered one, and if not, but you still think that there is a will, you will look for the indication that probate process was initiated somewhere. In Quebec, because there might be assets in some other jurisdictions, other provinces, other countries, then probably you'll have to search there. But we are talking about Quebec today. So this is it. This is where you usually start with when you think that there might be something to do with you, or you might have something to do with the estate, and that the information is not provided or hidden from you, or simply just maybe you are the liquidator, at least you think so, but you don't even know where to start. So you start with a will search, if you don't have a copy, of course. But even then, you'll need to prove that it's the last one, so still you start with a will search. Here it is. Thank you, and have a nice day.